case is N. Ray L.E.N., and the court is ready to proceed. You each side will have 15 minutes to present your arguments to the court, and the appellant may reserve up to 5 minutes. If you would just let me know, and I will try to keep time for you. Thank you, sir.
If you will reserve 2 minutes for me.
That's fine.
May it please the court, my name is Clifford Thornton. I'm an attorney who practice law in the state of Ohio now for 46 years. I rise on behalf of the appeal of Marie Noth, who was the wife of L.E.N. Noth, and has been his wife for the last 30 or more years. This is a tragic case, in my view. It represents a failure of the law to protect the sanctity of marriage and the wishes of an elderly man who was sinking into the abyss of Alzheimer's disease. When Mrs. Noth reluctantly agreed to the appointment of a neutral third-party guardian back in 2011, she did so in order to demonstrate goodwill to Mr. Noth's children, who had accused her falsely of trying to interfere with their relationship with their father. Now remember, here's a man who has been diagnosed with Alzheimer's disease. He's beginning down that long goodbye, and she is protecting him. She became his gatekeeper. But they falsely accuse her of intentionally interfering with their relationship. So she agreed to, at the instance basically of the magistrate, who, as you know, when these things occur, the magistrate or the lawyer many times get the lawyers in a room and they'll talk about the case, and the magistrate learned that there was a disagreement between the parties, and he says to the lawyers, well, I'll just appoint a third-party guardian. And of course, the lawyers, as you know how this works, go and talk to their clients, and the client says, well, okay, I guess I don't have a choice. So we agree to a third-party guardian, and she did that in order to show goodwill. What she did not agree to, however, was to give up all of her rights as a wife to care for her husband of 30 years during his last illness. She and her husband had planned together for her to take care of him. The evidence of that is a durable power of attorney that names her to be his agent. Healthcare power of attorney.
So, sir, if you can, okay, let me ask you a question. So you are indicating that whenever she agreed to the third-party guardian taking over, she was not aware that that would be in regard to medical decisions as well? Nobody explained that to her?
I know, she was not aware of that. She was trying to solve the problem. Well, if they think I'm trying to interfere with their relationship, fine. Let somebody monitor that. That's fine.
Whenever she agreed to it on the record, the court didn't explain to her anything as to what happened?
I wasn't there. I don't know.
And that record is not before us? It's not part of the record on appeal?
No, that particular part of the record. No, there is an earlier hearing record that has been received by the court. But she was trying to be a good person and help solve the problem. She did not realize that she was giving up, basically, all of her rights to care for her husband. And it soon became apparent because the guardian that was essentially unilaterally appointed by the court, and I'll get into that in a minute, turned out, not to be neutral. She essentially became an advocate for the children in all that they asked her to do. And she, as guardian, was very insensitive to Mrs. Noth's position. This is a very unusual case. Many times when there's a guardian, the person who's the ward has no family. They have nobody that cares for them, and so forth. Here you had a woman who has a man's power of attorney, his health care power of attorney, and his living will. They had planned that she would care for him in his last illness, and she now has somebody else who's a guardian of her husband, and that person was not really sensitive to the unique nature of Mrs. North's position. For instance, Mrs. North could not meet with the staff of the nursing home to discuss and plan her husband's care because he had a guardian. She could not meet or talk with her husband's doctors because her husband had a guardian who would not approve it. It wouldn't approve her talking with the staff at the nursing home. The guardian stopped taking her phone calls and would not read her emails. She wouldn't give Mrs. North a number to call her in an emergency. At one point, Mr. North had a stroke, and the guardian ordered the hospital not to treat him, but to send him home without consulting with Mrs. North about this decision.
During any of these incidents, did your client seek to have the guardian removed through the statutory procedure?
No. No, what my guardian, my client was more concerned about was trying to help her husband out. And there were a couple of times, one time he went to the hospital and the guardian was not around, she was on vacation. And so Mrs. North didn't tell the doctors that he had a guardian. So she could then be involved in his care. This really, she got really blasted by the guardian for doing that. How dare she interfere in her husband's care? The guardian signed off on a DNR without giving Mrs. North the courtesy of telling her she was going to do that. Now, there's a DNR in a man's living will declaration, but that doesn't give the guardian, the person who holds the declaration, first of all, it wasn't given to the guardian, and second of all, it doesn't give the guardian the right to do that unilaterally without doctor's approval. But again, in a situation where you have a wife who is perfectly competent to be the man's guardian, or the caretaker, who was displaced because everybody's worried about whether or not his children are going to be able to see him, it's very insensitive, at least not to discuss it with her, at least not to bring it up to her. In effect, the guardian froze Mrs. North out of her own marriage. I mean, her job was to pay the bill and keep her mouth shut, basically. And she went and visited her husband every day, but she couldn't make any decisions with regard to him. And so,
Counsel, in reading the briefs
uh-huh.
And the references that are made also in the magistrate's decision and the court's order, this doesn't come to us without the lower court having held hearings.
Mm-hmm.
And it's pretty inescapable that the trier of fact who had the opportunity to view the witnesses made some credibility determinations that are pretty stark. Sometimes we see, where the court will credit one side with regard to one thing and then credit the other. But it seemed as if the magistrate and then certainly the judge credited the children and the guardian to the exclusion of giving virtually any credit to your client. Would you agree with that?
I agree with that. May I be frank, Your Honor?
Certainly.
The guardian whom he appointed, by the way, without holding the hearing, he just wrote her name down and appointed her, and we'll get to that in a minute, is his go-to person. The court's go-to person for appointing a guardian. You need a guardian, nobody is available. This person, and when it came out in the trial, that she either has, and it's public record, that she either has or has had about 30 guardianships going with that court. He was very protective of her. Very protective of her. And remember, we did not ask for her to be removed, because, that probably would have been futile. What we were asking for is, after 3 years, and the children not having any trouble visiting their father, I mean, they never had trouble prior to that, but okay, after 3 years, Mrs. North said, I need to be in charge of my husband's care. And so she came back to the court and said, look, it's been 3 years, nobody's complained. Testimony was, nobody asked to enforce it, nobody asked to change it. And the visitation was going along just fine. So she wanted to be restored back to being able to care for her husband. Nobody said she was not competent. Even the court's investigator said that she was suitable to be the guardian, except everybody's worried about the kids. And the kids were saying, well, we're afraid that if she's the guardian, she won't. Well, they had no evidence to support that, except they went back 2 or 3 years and cited what they cited in the beginning. And there were two incidents where Mrs. North restricted their contact with their father. One was for 9 months, the daughter and her son came to visit every Wednesday and every Sunday. Every Wednesday, every Sunday. Wouldn't hear of not being able to do that, right? Well, he's got Alzheimer's. He's sinking into the abyss, right? She said, okay, we need to have some rules here. Call before you come, right? Because he may or may not be able to see you. On Sundays, don't come every Sunday because he and I may want to spend time alone together. We may want to go somewhere. Now that was thrown up as terrible restrictions. She's changing the whole world. Well, no, she's doing what a wife would do in the situation that she's in. She's being the gatekeeper. They didn't like her because when they would ask their father for money, she would say, "Don't do that anymore. He's going to have the money for his care." And then the second one was when he went to the hospital. First time he went to the hospital, he went from the hospital to a nursing home. It was time for him to get into a nursing home. He was very agitated about being there. If you know anything about Alzheimer's patients, there's a lot of paranoia involved. They're angry at the people who are trying to help them most. And so he's in the nursing home and he's agitated, and she consults with the administrator or the person in charge there. And they said, well, in this kind of a situation, it's very common for the family to restrict visitation for the first couple of weeks until the person gets to be acclimated. So she told the kids, don't come for the next couple of weeks so he can get acclimated. They made that into she's trying to interfere with our relationship with our father, and if she's the guardian, she'll cut us off.
Is this when the locks were placed on the door?
There was a lock placed on the door. I think it was at that location. She viewed.
No, I mean at that time, at that point in time.
No, I'm not sure if it was at that same time, but there was a point where she had a lock put on the door, which didn't restrict the kids from seeing their father. All they had to do was knock, and the staff had the key. I mean, it
And this
wasn't.
was when he was in assisted living, right?
Yeah.
He had his own apartment.
Yeah, right. So she came back to the court and said, look, let's change this so I can be in charge of my husband's care. If you want to appoint me guardian, then you can control whether I'm letting the kids visit or not. Or I'll just take care of him using the healthcare power of attorney and the durable power of attorney and so forth, the way normal people do when they don't ask for guardians. She, by the way, followed the advice of counsel.
I hate to interrupt you, but you're at your 2 minutes.
I'm at,
2 minutes. If you want to save the 2 minutes, you need to stop.
oh, I'm already used up 8 minutes?
Yes, you have.
Or whatever it is. Does time go by
Yes, it does.
in a hurry?
It sure does.
Well, let me just say, if you will, a concluding statement, and then I will be gone. Mr. Knopf is getting worse. He's failing. By all accounts, he's coming to the end of his life. And tragically, his life of over 30 years has been systematically frozen out of his care for almost 4 years. And why was that? Basically to protect the fears of 2 children who rarely ever come to see him. That's right, after they won the case, they hardly ever come to see him. One of the son who was most vociferous about being cut off had to admit under cross-examination he hadn't seen his father in 8 months. And he could only prove that he'd seen him once in 14 months. And of course, now they rarely come to see him at all. It's time to restore the decision regarding Mr. Knopf's health care back to his wife. This case should be frightening to every woman, or man for that matter, who may be put in the position of caring for their spouse during their last illness. Children, we love them, but they should not be able to displace a man's wife so easily. It's a bad precedent to set. What's needed is to terminate the guardianship altogether or institute a limited guardianship. That we cited plenty of law in our brief as to our position on that. And I'm out of time. Thank you so much.
May it please, good morning. May it please the court, I am Shireen McGee. I am the court-appointed guardian for L.E.N. I've been his guardian since January of 2012. I am here just simply to ask that you follow the trial court's order and continue the guardianship. Mr. Knopf, as I believe that the trial court found that Mrs. Knopf has an insidious personality, that she makes decisions not in the best interest of her husband but for herself, and that had she been appointed guardian, the children would be alienated from their father and not have any type of relationship. And therefore, I am requesting that you continue to uphold the trial court's decision not to terminate.
And that argument goes to the visitation and so forth, but obviously there's a difference between visitation and the healthcare decisions.
Yes, ma'am. Unfortunately, some of the decisions that Ms. Knopf would make would be, again, for her own benefit. If she were in a position to make the decisions currently, she would like Mr. Knopf to be in hospice and being sedated, is what she's requested. And no, it's not in his best interest at this time. He is what you would call a walker. He walks most of the day. Although it's not physically good for him, that's what he wants to do. And both the physicians and the nurses at the facility feel that it's in his best interest to get up and move around. And to sedate him to not do that would be detrimental to his health.
You have anything else?
No, ma'am, any further questions?
No, Lisa. Thank you.
Thank you.
You still have about 13 minutes with your side.
Thank you. May it please the court, my name is Carol Hamer, and I represent Sue Fatal and Lauren Knopf, who are the adult children of Larry Knopf. I would like to briefly address some of the arguments contained in Marie Knopf's reply brief, because we believe that we've already addressed the arguments contained in her initial brief. Basically, the appellant raises two issues on appeal. The first is that the trial court's order was against the manifest weight of the evidence. With respect to that argument, it is well settled that a court will not overturn the trial court determination on a manifest weight of the evidence challenge because the trier of fact chose to believe one witness or more witnesses over another. The trial court here chose not to believe Mrs. Knopf. The trial court made that choice after conducting 4 separate hearings, listening to hours of testimony, observing the demeanor of the witnesses, and examining the exhibits introduced by the parties. This is simply not the exceptional case where the appellate court, after reviewing the entire record, can find that the probate court clearly lost its way and created a manifest miscarriage of justice. Mrs. Knopf also asserts that a variety of the probate court's actions were an abuse of discretion. It is well established that a probate court has a wide discretion when appointing a guardian. Guardianship matters are reviewed by appellate courts under abuse of discretion standard. A review under that standard is a deferential review. An abuse of discretion standard requires this court to find that the probate court acted with an attitude that was unreasonable, unconscionable, or arbitrary. The probate court did not. In her reply brief, Marie Knopf asserts that the court abused its discretion in 3 additional ways that she didn't identify in her initial brief. And the first one of those was that the court should have appointed Mrs. Knopf in 2011 to serve as the guardian. Unfortunately, that's simply not what happened in 2011. In 2011, Mrs. Knopf agreed, along with Sue Fatal, who had filed a competing application, that she was not willing to serve as guardian. She, in essence, admitted that neither of them were suitable because of the family dynamics. The 9th District case that she cites, McCaney, is simply not applicable. In that case, the guardian named in the power of attorney was competent, suitable, and willing to serve. Here, Mrs. Knopf nor Mrs. Fatal were in 2011 when they agreed that a third-party guardian should be appointed. And secondly, in her reply brief, she asserted that Marie Knopf asserted that it was also an abuse of discretion that the court did not hold a hearing when the first guardian, Mr. Ian Haberman, resigned. The court then, upon the motion of Sue Fatal and Mrs. Knopf, appointed Shireen McGee. Given the fact that that appointment was more than 5 years ago, Mrs. Knopf has long waived any objection to the appointment of Shireen McGee without a hearing. And in
Is there a
essence,
statutory requirement for a hearing?
there was a statutory requirement for a hearing in 2111-02, but since it's been 5 years, there's really no issue on appeal any longer for that. And also, Marie Knopf actually invited the court to do so. She filed a motion asking for the court to appoint a replacement guardian. And then finally, Mrs. Knopf asserts that because of that failure to hold a hearing, that somehow the letters of appointment were improperly issued under 2111.47. And that's simply a wrong reading of that statute. 2111.47 finds that upon the, if letters of appointment were improperly issued or the guardian or the ward is returned to competency, then the guardianship is terminated, means the ward is returned to competency. So what 2111.47 anticipates and is about competency and removing and terminating guardianship when a ward returns to competency. So therefore, it's got nothing to do with the fact that the hearing was not held in 2011. Finally, appellant asserted a variety of evidence that's not in the record. There is no evidence in the record as to what happened when the magistrate held the hearing at which Mrs. Knopf agreed that an independent guardian should be appointed. There's simply nothing in the record.
There's nothing in the record of what?
About what happened in the magistrate's courtroom when Mrs. Knopf agreed to the appointment of a third-party guardian in 2011. Finally, Mrs. Knopf has failed to demonstrate that the probate court's decision was against the manifest weight of the evidence and has not demonstrated that the probate court abused its discretion. I urge the court to affirm the trial court's order.
Thank you. You have literally 10 seconds if something like say 10 seconds.
We just read one thing to the court. This is Revised Code 1337-12. If a guardian is appointed for the principal, a durable power of attorney for health care is not terminated, and the authority of the attorney, in fact, continues unless the court, pursuant to its authority under Section 211150 of the Revised Code, limits, suspends, or terminates the power of attorney after notice to the attorney, in fact, and upon a finding that the limitation, suspension, or termination is in the best interest of the principal. There has never been a hearing, there has never been notice, there has never been a limitation of the durable power.
Thank you. We'll take a matter under advisement and issue a written opinion that will be sent to both sides. And you also can look on the Supreme Court website and this court's website for the release of our opinions as well. Thank you very much.